So this morning's discussion is about medical malpractice. Well, let's start at the beginning, the most basic thing. What is medical malpractice? It's really nothing more than medical negligence, medical carelessness, the carelessness of a physician, right? We like to say that there's a departure from good and accepted medical care, or a violation from the basic standards of medical care. That's what it is. Okay, but we're attorneys in this room. What do we need to make out a prima facie case to prove a case? Well, we need liability, causation, and damages. All right, that's nice and theoretical, but that doesn't help us. What about this scenario? What about explaining it this way? We need to show that the doctor was careless. We need to show that the carelessness was a cause, it doesn't have to be the cause, of the injury, and we need to show that the injury is significant and or permanent. Those are the three things that we need to make out a prima facie case of medical malpractice. But you should know something else. In order to go ahead and bring a lawsuit in New York, we are required to have a medical expert go ahead and review all of the patient's records to confirm each one of those three elements: liability, causation, and damages. If our expert cannot give us that confirmation, we can't go forward with the case. So the law requires us to have a medical expert. And you're going to hear a little bit later on that there's only one instance, one situation in which we will not need and will not require a medical expert. But I'll get to that later. Okay, so now you're chatting with somebody. Maybe you have a problem with your computer. You work in a big firm, and you call up the IT department, and they come and fix your computer. And you make some small talk with the guy fixing your computer. And you say, hey, how's it going? And he decides to answer you truthfully and tell you, oh my God, this is horrible. I just had a horrible situation. My father just died. He went into the hospital for a urological procedure, and now that went great, but 2 days later he was dead from a massive stroke. And you start to ask questions. But you make the mistake of saying, tell me what happened. And I'm going to suggest to you, absolutely under no circumstance are you to ask that open-ended question. Because the moment you do that, in your kind and gentle way, you are opening the door to allow this person to go ahead and go on for a long-winded narrative that's going to go on from 45 minutes to an hour. And it will be just like you are in law school again, or sitting for the bar exam, trying to sift through the facts that are important and the issues that are important. And you don't want to do that. There's a better alternative. Would you like to know what it is? The alternative is to ask a single question. It's a compound question. It's one that calls for multiple answers within the same question. And I'll tell you what I mean. So instead of turning around and saying, hey, tell me what happened, as if you're doing a consultation and now the client gives you a long-winded narrative that goes on forever, what I suggest you do is to ask, what do you think was done wrong, and what injury did you suffer as a result of that? Contained within that one question are the three elements that we need to evaluate whether or not there may be a valid basis for a case. What do you think was done wrong? In almost every instance, the injured patient will be able to tell you, at least most of the time, what they think was done wrong. But then the second part of the question stops them cold, because they're not focused on the link, the causation, the bridge between the wrongdoing and the injury. Why? Because they don't know what is needed to prove a case. So when you ask that question, they'll tell you what was done wrong, but then they'll stop and say, wait a second, did that cause the injury? I don't know if it caused the injury. And now they'll have hesitation. And that's natural. So don't expect them to know the answer, but they will always know what injury or damages they have. And then you, as the attorney, may be able to put the pieces of the puzzle together and connect the dots. But that quick question, in just the first few moments of talking to them, will give you a sense of what type of case this may be and what type of damages and injuries this person may have. So now you're on the path to learning great information and what you need to know. All right, what else do you need to know? The most important thing for you in talking to this person for a few moments is to know whether or not, what? Whether the matter is timely. Because if it's not timely, guess what? It doesn't matter how horrible the medical care was. It doesn't matter what injuries they suffered. It could be the worst injuries in the world. If the matter's not timely, there's nothing you or I or anybody else can do. So this morning's discussion is going to explore a great deal about when are these cases timely and what you need to know to help them make an educated decision about what to do next.